Mr. Jones.
All right, hold on 1 second. All right, good afternoon, everyone. I am Judge Regina Mincy, and we are going to begin with our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made and accepted at this juncture. I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. I want to remind the defendants of your constitutional rights. You have a constitutional right to remain silent. Anything that you say about the facts and circumstances of your case can and will be held against you. The solicitors are here and they're listening. So listen to your attorneys and govern yourselves accordingly. I want to also remind you that you have a constitutional right to have representation by an attorney at this juncture of your case. Most of you do have that, and you know who your attorneys are. We will start, you said position 7.
Position 6.
Oh,
John.
sorry.
The reset date for the SAP calendar is going to be December the 15th.
Yes, thank you. Forgot about that. December 15th. All right.
I'm sorry, what was the date, Ms. Bridgewater?
December the 15th.
Thank you.
Mm-hmm.
All right, for position 6, it is case number 22 CR 008068J. Brent Jones, you're charged with 1 count of disorderly conduct. Actually 3 counts of disorderly conduct and a 4th count of public drunk, and actually 2 counts of public drunk. So I'm sorry, 3 counts of disorderly conduct, 2 counts of public drunk. The offense date is November the 30th, 2022. Pre-trial.
Good afternoon, Judge. 2 cycles, last arrest, July of 2020, for criminal trespass, willful obstruction of law enforcement officers by use of threats of force or violence, simple battery against police officer. That was arrest in Fulton County. It was dismissed. He has a 2016 criminal trespass misdemeanor conviction. Nothing further.
All right. And the prosecutor on this case.
It's my case, Your Honor.
Okay, go ahead.
Yesterday, while on patrol, Officer Eric Reynolds was flagged down by an employee of the Exxon gas station located at 1105 Holcomb Bridge Road. The employee informed the officer that the defendant was inside the gas station, cursing, yelling, and threatening to fight the store clerks. At the request of the employees, Officer Reynolds simply escorted the defendant from the premises and continued on his patrol. Less than an hour later, Officer Reynolds was dispatched to the Economy Motel located at 9995 Old Dogwood Road on the reports of a man who appeared to be drunk, arguing and trying to fight motel patrons. When the officer arrived, he realized that it was the defendant again. Officer Reynolds removed the defendant from the premises, advised him of the seriousness of his actions, and let him go with a warning. 2 hours later, Officer Reynolds was dispatched to the La Quinta Inn located at 575 Old Holcomb Bridge Road on similar reports of a drunk man attempting to fight hotel patrons. When he arrived, he again saw that it was the defendant. After confirming that the hotel staff that he was the man, in fact, trying to fight patrons, he placed him under arrest. As pretrial stated, he does not have a lengthy criminal history. However, we are concerned with the risk of reoffense, seeing as he committed offenses at 3 different locations within the same day after being given a warning the first time. We are asking for a $500 surety bond for each individual count. That's $500 on count 1, $500 on count 2, $500 on count 3, and $500 on count 4, and another $500 on count 5. Making that a total of a $2,500 surety bond. We are also asking for a stay away from the La Quinta Inn, the Economy Motel, and the Exxon gas station, as well as no drugs, alcohol, or weapons. Nothing further.
Okay. All right. And who do we have representing?
PD Kim.
Oh, PD Kim, yes.
Yes.
Good afternoon.
Good afternoon, Your Honor. Mr. Brent Jones is 23 years old and he has his parents and his brother and sisters. However, he has not have any contact with them lately. So he does not have anybody to pay for his bond. He has been employed at Bad Daddy Burgers as a cook for the last 2 months, but he's afraid that if he does not get a signature bond from this case, he's afraid that he may lose his job. So we want to get out of this jail as soon as he can to keep his job. And he has 11th grade of education, and he's currently pursuing to get GED. Also, I will be requesting social worker services to provide housing resources for him, since he is staying at his friend's house for about a month because he is residentially challenged. However, he has a mailing address at First Presbyterian Church, and so we will be able to send out the notice of hearing. We would like to request for a signature on bond. And if Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $1,000 for total. So that means $200 for bond for each count. Thank you, Your Honor.
Okay. All right, for Mr. Jones, I'm going to enter the $2,500 surety bond, which will be $500 on each of the 5 counts. With that $2,500 surety bond, you are to stay away from the La Quinta Inn, the Economy Hotel, all there, I believe, on Dogwood Road, and the Exxon on Holcomb Bridge Road. You're not to go back to any of those locations. You are to have no drugs, alcohol, or weapons while you're on bond. And I think that's it. Anything else that I need to take up, counsel?
Just really quickly, Your Honor. The Economy Motel is the only location that's on Dogwood Road. The La Quinta Inn is on Old Holcomb Bridge Road, and the
Oh.
Exxon is on Holcomb Bridge Road.
Okay, so we have three different addresses, Old Holcomb Bridge, and Old Dogwood. Do you have all of those, Ms. Bridgewater? You're on mute.
I'm sorry, I was writing as you were saying that, but I do have them all.
Okay, you've got all three addresses.
Mhm.
All right,
That's La Quinta Inn, the Economy Hotel, and the Exxon Gas. I have them all three.
great. All right, so you understand, Mr. Jones, you're not to go back to any of those locations, okay? All right, that will conclude this matter.
Judge, can you repeat the bond, please?
$500 on each of the charges, total of 5 charges, so that'll be 2,500 good bond, surety bond.
I'll tell you. Okay, you're done. All right, position 5, Johnson.
Okay,
Good afternoon, Your Honor.
good afternoon.
Hey, Ms. Bridgewater, hey, Judge.
Mr. Johnson will be proceeding pro se with the plea.
All right, do we have that paperwork?
I do not know if the prosecution has forwarded to the jail or not.
It was forwarded to the jail.
Thank you.
Yeah, they're getting the paperwork together now, so they're gonna send it back.
All right, so
Honor,
we'll
if
probably
I-
take another case while
Right.
it's doing that.
If I may make a request that these two positions be held until the end of the calendar. So courtroom 2, if we could position those toward the end of the calendar so that we can get that paperwork and forward it to Ms. Bridgewater.
All right, so that's position number 5, Mr. Johnson, and you said 2, Ms. Falk, there was a second one?
Position 9.
Okay, 5 and 9, okay. Thank you.
We'll move on to position 3, Haney.
Okay, I have Haney as position 3.
Yes, that's correct, Judge.
Okay, and that's 22 CR 008070 B as in boy, Dion Haney. And Mr. Haney, you are charged with 1 count of possessing of a pistol or revolver by a person under the age of 18 years of age. You're also charged with reckless conduct. The 3rd count is willful obstruction of a law enforcement officer. And the offense date is November the 30th, 2022. Pre-trial?
4 cycles, last arrest August of 2022 for willful obstruction of law enforcement officers, 2 counts, entering auto or motor vehicle with intent to commit theft or felony, 2 counts, and criminal damage to property, 2nd degree. That is an open case, 22 CP 211478. Record reflects 4 cycles, but 2 of those are juvenile arrests. Disposition is not known. 2021 armed robbery, 2021 theft by receiving stolen property. Nothing further to add.
All right, Ms. Sorry.
Yes, Your Honor. Good afternoon. This incident took place at 520 Fulton Street Southwest in Atlanta. The victim in this case, whose name is Carla Baker, she called police to report hearing a gunshot in the hallway of her apartment complex. Officers responded and they saw the defendant and another person walking. And when they saw the officers, they turned the other way and began to run. One of the officers saw the defendant running towards a parking garage, and the defendant was detained. A gun was also found near the defendant. And by spontaneous utterance per the report, the defendant claimed ownership of the gun and that he and another male were struggling over the gun when it went off. And Your Honor, there was a 9mm shell casing that was also recovered. As we've heard from pretrial, the defendant has 4 cycles. He's only 17 years old, Your Honor. He has 4 arrests. 2 are juvenile and 2 are, well, they're all juvenile. However, they all include firearms. The open case that he has in Superior Court, the Enter Auto Criminal Damage to Property Obstruction, he was given a $17,000 good bond on that case, and that was in August of this year. And now here he is 4 months later with another charge. So he does present a significant risk of reoffending. He's a danger to the community, and he does present a risk of flight. The state's recommendation in this case is a $30,000 surety bond. That's $15,000 on the possession of the firearm, $10,000 on the reckless, and $5,000 on the obstruction. A stay away from the incident location and no drugs, alcohol, or weapons.
All right. Ms. Gant?
Thank you, Your Honor. Mr. Dion Haney is 17 years old. He has been in the Atlanta, Georgia area his entire life. He has family here, including his mother, grandmothers, sisters, and cousins. He is currently enrolled in a GED program. He is working on his exams now to obtain his GED. He is unemployed at this time, Your Honor. He has worked in the past with his uncle, in terms of like fixing cars and HVAC equipment. He is presumed innocent, Your Honor. These are allegations. My client denies the allegations, and I would bring to the court's attention, we'll ask that your court not consider any of my client's juvenile offenses, and we have not heard about any convictions whatsoever. So for these reasons, Your Honor, I'm requesting a signature bond for Mr. Haney. He just doesn't have the means to make a $30,000 bond. That is excessive. If Your Honor determines that he is ineligible for a signature bond, then I would ask for a more reasonable bond, and that bond would be no more than $3,000, $1,000 for each offense, Your Honor. And with regarding the prosecutor's contentions or risk of reoffense, again, he has not been convicted of anything. We did not hear about any FTAs whatsoever, Your Honor. We are also finally unopposed to any stay away conditions at the incident location, Your Honor. Thank you.
And Your Honor, we just want to stress the fact that this defendant is 17 years old. Again, all of his arrests include a firearm. He's a significant danger to this community, being under age 1 with a firearm and then letting it discharge in a reckless manner. So again, we are going high on this bond. He was just given a $17,000 bond on similar accounts, and here he is again. Nothing further, Judge.
All right. I'm going to enter a $15,000 surety bond. And with the breakdown on that 15,000, the first charge of possessing the pistol will be $10,000 surety bond. And on the second charge, reckless conduct, will be 2,500 surety bond, and the willful obstruction, 2,500. So a total of 15,000 surety bond. No drugs, alcohol, or weapons while on bond. Also, do we have a cosigner?
Your Honor, his mother, Brianna Cheney, is willing to co-sign for him.
Okay.
I did speak with her and she is on the line.
Okay, Ms. Cheney.
Are these good bonds?
Yes.
So he needs a co-signer on a good bond?
Oh, well, it would go through the bonding company. I apologize.
And Your Honor, I'm sorry, may I add a stay away from the incident location and no further contact with the witnesses? And of course, I think you already said no drugs, alcohol, and weapons.
All right, we've got a stay away. I'm going to add a stay away from the incident location and no further contact with, did you say a witness and a victim or just the witness?
She's a victim witness. Her name is Carla Baker.
And the defense is unopposed.
All right.
You're done.
And that will conclude this case. I believe that the mom, Miss Haney, is
Henson.
off of the Zoom, or she's still here. Oh, there she goes.
I'm
Okay.
here.
Okay, I couldn't see you. I'm sorry, Miss Haney.
And she is here to just observe, Your Honor.
Correct.
And Judge Mincy, I know you said no alcohol, drugs, and weapons, but I would like for it to be more specific, no firearms, because we've had this come up before, and I want a specific no firearms provision. Not that he should have them anyway, because he's not 18 yet.
Not 18, right? Yes, let's clarify that, Ms. Bridgewater.
I have it as no drugs, alcohol, weapons, or firearms.
Thank you.
Thank you, Ms. Bridgewater.
You're welcome.
All right, anything else, counsel?
Nothing from the defense, Your Honor. Thank you.
All right, thank you.
This
Oh,
is
yeah.
position 4, Henson.
What number?
Position 4, Henson.
All right. Give me 1 second. All right.
And Your Honor, I do apologize again. For position 3, due to the fact that he is a minor, may we add a curfew?
Very good point. Thank you, Ms. Sorry. He does make bond. And I apologize. We're going back to that. Usually I do about 8 p.m. or 9 p.m. With him, maybe I would do 9 p.m. to 7 a.m. for the curfew.
Could we request 8 p.m. to 6 a.m., Your Honor?
I'm sorry.
8 p.m. to 6 a.m.
All right.
The defense would ask for 9 to 6 a.m. My client is currently seeking employment, Your Honor.
And I know you said he was working on his GED,
Yes, Your Honor.
and I'm assuming he's taking public transportation.
Yes, Your Honor.
I will stick to the 9 p.m. to 7 a.m. I'll do 9 p.m. to 7 a.m. on the curfew.
Thank you, Your Honor.
Uh-huh. So now we have position 3.
Well, this is position 4, Henson.
I'm sorry, position 4. This is Emmanuel Henson, case number 22 CR 0008075Y. We charged Mr. Henson with 1 count of willful obstruction of a law enforcement officer, 2nd count of willful obstruction, actually 3 counts of willful obstruction of a law enforcement officer, all with the offense date of 11/29/2022. Pretrial.
5 cycles, last arrest, May of this year for disorderly conduct and obstruction of law enforcement officer. That is a conviction under case 22 CR 002914Y. Sentenced May of this year, 12 months probation. Additional open probation for possession of firearm or knife during the commission or attempt to commit certain felonies. Case number 21 F as in Frank, T as in Tom, 0054911. Sentenced September of 2021, 5 years probation. That is out of Gwinnett. It is first offenders. Also, it is to be served consecutive to count 1 is to be served consecutive to count 2. Nothing further.
All right. Ms.
It's mine.
Farmer?
Yes, Your Honor. This incident took place at 880 Holcomb Bridge Road in Roswell. Officers were dispatched to the incident location regarding a trespass call. The defendant was sleeping in the breezeway of the business and littering with all of his belongings all over the property. The defendant had been criminally trespassed. In the past, he's been given multiple warnings. Upon the officer's arrival, he found the defendant in the parking lot and asked for his name and date of birth. The defendant refused to provide all of the information and then became irate. He also attempted to flee on a bicycle. And when he was ultimately being arrested, he resisted by pulling away. As we've heard from pretrial, the defendant does have multiple cycles in his history. He presents a risk of reoffending due to the multiple trespass, his history of a disorderly conduct and obstruction guilty conviction that was just 7 months ago. He does have that first offender for possession of a firearm, so he is a violent offender. Your Honor, the state's recommendation is a $3,000 surety bond. That's $1,000 on each count, a stay away, and no drugs, alcohol, or weapons.
All right. Ms. Gant?
Thank you, Your Honor. Mr. Emmanuel Henson is 22 years old. He has been in the Atlanta, Georgia area for 1 year. He does have family here, including a mother, a sister, and a cousin, none of which is available to assist with bond. Mr. Henson is residentially challenged. We are putting in place a social worker consult to connect him with services. Mr. Henson is working on his GED at this time. He was last employed at Wendy's about 2 months ago, Your Honor. Mr. Henson denies the allegations, and it appears that my client was arrested primarily because he is poor. He does not have the means to pay anything toward bond, Your Honor, and I would ask that even though he does have some history of violence, this is a non-violent offense, and I would just ask that given the nature of the allegations, that Your Honor would grant my client a signature bond as he just doesn't have the means to pay, Your Honor, and we are unopposed to any stay away conditions. Thank you.
And Your Honor, just for the record, the defendant was not arrested because he's poor. He was arrested because he was previously criminally trespassed and he keeps returning to the same incident location. So that's the reason why he was arrested.
That's not true because they never.
Mr. Henson, please remain silent, sir. We don't want you to say anything to jeopardize your case. It's not about guilt or innocence, just a bond hearing, sir.
All right. I am going to grant the $3,000 surety bond, which will be $1,000 on each of the charges, for a total of $3,000. For a $3,000 surety bond, I'm going to order a stay away from the incident location, Holcomb Bridge Road. So please, if you make bond, Mr. Henson, do not go there, else you'll be rearrested again. Cannot be on that property. And I'm assuming that's an apartment complex, I think.
No, ma'am.
No, it's a home.
No, ma'am.
Please,
Mr. Henson,
Henson, please remain silent, sir.
Mr. Henson, I'm not asking you these questions.
Oh, I can.
And Your Honor, I'm looking into that right now. I apologize.
Are you aware at all, Ms. Gant?
I am not, Your Honor.
It appears to be multiple businesses
Okay,
located here.
okay. So it's businesses, okay. So to that area and those businesses, Mr. Henson, you're not to go back there. Sounds like there could be other businesses that could bring the same complaint against you if it's some type of strip location or strip mall type location with breezeways. So just stay away from that whole area of the 880 Holcomb Bridge Road. No drugs, alcohol, or weapons while on bond. And to stay away. I think that will be it at this time. Anything else, counsel?
Nothing further from the state.
All right,
Nothing from the defense, Your Honor. Thank you.
thank you.
Position 11, Thompson, you're done.
Okay, so what? Dang, tell me what to do.
Come on, Thompson.
Did you say Larry Thompson or Laquan Thompson?
Laquan Thompson, let me double check. If that's position.
Okay, thank you.
I agree, we do have two.
Yeah, it's Laquan Thompson, position 11.
11, okay. E. All right, this is case number 22 CR 008074E. Laquan Thompson, you're charged of 1 count of forgery in the 4th degree. The offense date is November the 30th, 2022. And pretrial?
41 cycles with history in Georgia and Virginia. Last arrest September of this year, failure to appear, Fulton County. Underlying charge was not indicated. Record does reflect an open probation for theft by taking and simple battery. 22 CR 003096A. Sentenced September of this year, 12 months probation. Record indicates 2 failure to appear and 3 violations of probation within the past 10 years. A 2018 criminal trespass misdemeanor convictions, 2 simple battery in 2017, a 2017 simple battery, 2 counts, 2 misdemeanor convictions in 2012 for theft by shoplifting, and a 2012 battery. Nothing further to add.
All right, ASG Giddings,
Yes, thank you. Good afternoon, Your Honor.
afternoon.
This incident took place at the Citizens Trust Bank located at 3705 Cascade Road, Southwest Atlanta, 30331. Mr. Thompson attempted to cash a check that was drawn on an account by the Sadie G. Mays Nursing Home Rehabilitation Center. And when it was presented to the teller, it looked strange. And so she made a couple of phone calls and found out that it was in fact an invalid check. The police were called and they stalled in order for the police to arrive so that the defendant would not leave the location. When he was questioned by police, he indicated that he does construction and he got the check from some unknown female, didn't give a name of this person, nor did he provide the name of a company that he was working for during this construction. He has 10 total cycles in Virginia, including today, 25 cycles in Georgia, and he has several convictions for shoplifting, several convictions for larceny, some theft, some larceny from a person where he was pickpocketing and then presenting bad checks. So we think that there is a risk of offending. So we would ask that he be given a $2,500 surety bond. The officer took out 2 warrants, one for Citizens Trust Bank for presenting the instrument, and then one for Sadie G. Mays Rehabilitation and Treatment Facility because it was a check supposedly drawn on their account. However, the state is only proceeding on 1 count, and we sent an NOD for the 2nd count, which is why we're asking for 1 bond, $2,500. The 2nd charge has been dismissed.
So this first forgery in the 4th degree, the victim in this case is going to be, is it just the Sadie G. Mays? Which one do we have left, this forgery in the 4th?
It would be Sadie G. Mays.
Okay.
Because he actually did not get any money from the bank because they didn't honor the check. So it would be Sadie G. Mays Nursing Facility Rehab and Treatment Center.
Gotcha. All right, thank you.
Mhm.
All right.
Oh, my apologies, Your Honor. We're asking for a stay away from Citizens Trust Bank at the 3705 Cascade Road address. And he did not get that check actually from the facility at Sadie G. Mays. So I will defer to the court whether or not you wishes that he stay away from there. I don't know if he has a family member that is a resident at the nursing home facility.
All right. Ms. Gant or?
Actually, Petty Kim.
Ms. Kim.
Yes.
Okay.
Mr. Thompson is 40 years old and he has been here in Georgia for about 9 years. He has 2 children and they are 9 and 11 years old. He has parents and brother and sister here in Georgia. He also is employed as a cleaning personnel. He has been working there for about 3 months. So he does have a ties to the communities and he's not a flight risk as his highest level of education was up to 11th grade and he is actually planning to take GED school. Your Honor, we would like to request for a signature on bond for this count. And yet, if Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $1,000 good bond. Thank you.
All right. I'm going to, excuse me, order a surety bond in this case in the amount of $2,000. That surety bond in the amount of $2,000, there will be no drugs, alcohol, or weapons while on bond. We're going to order a stay away from the Citizens Trust Bank at 3705 Cascade Road. And I think that will be it. I will not order a stay away from the Sadie G. Mays facility. I've not heard any evidence that he has any reason to be there, unless the state has a stronger argument as to why we would need to add another location for that stay away.
No, Your Honor, we do not.
All right, thank you. Anything else, counsel?
Nothing for the state, Your Honor.
Nothing further from defense.
All right, that will conclude this matter.
Thank you.
Mhm. Courtroom 2. Don't know if they realize they're muted.
Yes, Judge.
Sorry.
No, you said something?
Right, I didn't know the next case to be called. I think you were muted.
Position 8, Sandoval.
Okay, 8, thank you. All right, position 8. Excuse me. This is 22 CR 008072F. And it looks like the name is Benjamin Sandoval Maya. You're charged with 1 count of criminal trespass and damage to property. That offense date is November the 30th, 2022, pretrial.
Let's see, second arrest. First arrest was April of this year, theft by shoplifting in Fulton County. No disposition listed on that arrest. Nothing further.
All right. And ASG Todd.
Thank you, Your Honor. Yesterday, following a verbal altercation with his mother, Bianca Maya Cervantes, that's BIANCA, Maya, the same spelling as the defendants, hyphen Cervantes, CERVANTES. The defendant proceeded to walk out of the room and kick a bedroom door so hard that it cracked the door frame and the door, leaving significant damage to both. While the defendant does not have an extensive history, he does have that open theft by shoplifting. It has been bound over to Fulton County from Roswell Municipal Court. However, we just haven't received it yet. The state is asking for a $1,000 surety bond with no further contact, a stay away from the home of Ms. Cervantes, which is 6006 Gardner Drive in Alpharetta. No drugs, alcohol, or weapons, and 1 day of anger awareness. Nothing further.
All right. Ms. Kim?
Yes, Your Honor. Mr. Benjamin is 19 years old. He was born and raised here in Georgia. And of course, he's a single and he resides with his mother. However, he does not oppose to stay away or no further contact. He's gonna go to his uncle's place. Your Honor, he's been working as a full-time jeweler at one of the mall, and he has a job there for about 3 to 4 months, and he would like to keep that job. And he also has high school diploma. And we would like to request for a signature on bond for this case. Regarding that theft by shoplifting, my client says that actually happened on October 2021, and it was misdemeanor, and his attorney should have taken care of all that, and he believes that it was already closed. And yet, apparently, I guess, we don't know how it got transferred to state court at this point. Since we don't have a clarification about that, I don't want the court to have too much weight on that. We would like to request for signature on bond. I believe he is qualified. Thank you.
All right. I'm going to enter a $2,000 signature bond through pretrial. I'm going to order no further contact with his mother, and I did not write down her name. And I think is the last name backwards on the calendar possibly? Is it Maya Sandoval or Sandoval Maya?
It is actually Maya Cervantes.
Oh, a whole different last name. Okay.
Different last hyphen, yes, ma'am.
Okay. All right. And it's Bianca.
Yes, Your Honor.
Okay. So no further contact with the victim in this case. A stay away from 6006 Gardner Drive. No drugs, alcohol, or weapons while on bond. And the one-day anger awareness course through pretrial. All right, and that will conclude this matter unless council has anything else.
Nothing from the state.
Nothing further from defense.
All right.
Position 10.
All right, this is 22 CR 008069G. Tamika Taylor, the charge at one count of criminal trespass and damage to property, and the second count of battery, substantial physical harm, both with the offense date of May 26, 2021. Pretrial.
I'm sorry, Judge, what position?
10, Tamika Taylor.
1 moment.
Okay.
3 cycles out of Illinois, last arrest February of 2012 for a resistant peace officer. That was a misdemeanor conviction. Nothing further to add.
All right.
That would be me, Your Honor.
Okay, go ahead.
Yes, Your Honor. This incident took place at Planet Fitness located at 854 Oak Street, Southwest Atlanta, 30310, where Ms. Taylor entered the location and attacked the receptionist, Ms. Nosha, that's capital Nosha, Harwell, common spelling, and they knew each other very briefly, Your Honor. Ms. Harwell had noticed that Ms. Taylor had been residing in her car in the parking lot on several days. And after approaching her and asking her what was going on, she allowed Ms. Taylor to enter into her home, and she resided there for approximately 3 weeks over a 2-month period. She left. Ms. Harwell had no contact or communication with Ms. Taylor for about a month, and then a cable bill showed up in the mail at Ms. Harwell's home, and Ms. Harwell had not elicited nor installed cable in her home. So she called Ms. Taylor to ask her, "Did you put a cable bill in my name?" Ms. Taylor responded, and I'm paraphrasing, "No, I did not, and I'm not talking about this anymore," and that's all I have to say. Later on, because of that conversation, we surmised Ms. Taylor then went to Ms. Harrell's job at the Planet Fitness, where she had been sleeping in her car, and attacked Ms. Harwell. The police were called, and when the police got there, they were told that the entire incident within the lobby area was captured on closed circuit television, and that corporate would be able to provide that video footage to the police officer for evidence. And then when Ms. Harrell went outside to her vehicle, she found that all 4 of her tires had been slashed, and an independent witness was present, and his name is, I'll give it to you in just a second, I wrote it down, Mr. Burks. Mr. Burks, Isaac Burks, indicated that he saw Ms. Harrell tires being slashed by Ms. Taylor. To do an ID to make sure that she was indeed the person, the officer pulled up Ms. Taylor's Georgia identification card with her photo, and Mr. Burks, as well as Ms. Harwell, were able to identify Ms. Taylor, and that is how they knew they had the right person. Given the fact that she does have some limited history, this is her first arrest in Georgia, and she only has 3 cycles out of Illinois. However, the disorderly conduct from 2020 did not have a disposition because it mandated not to be reported, but there was a 2010 domestic battery that was dismissed on the state's motion in Illinois. Given the fact that Ms. Harwell opened her home and her heart to Ms. Taylor, and it seems that that was not appreciated based on these events, we would ask that for the criminal damage to property, for the slashing of all 4 tires, a $2,000 bond, and on the battery, we would be asking for a $3,500 bond. And I admitted to advise Your Honor that Ms. Harwell received a small knot on her forehead and a scratch under or near her left eye as a result of this attack. We would also ask for a stay away from Ms. Harwell's home, as well as the Planet Fitness where she is employed. We don't have a home address for Ms. Harwell. That was not in the warrant or the police report, so we would just need to say stay away from her home address. We do have the address for the Planet Fitness and standard bond conditions, no weapons, drugs, or alcohol during this time.
Right?
Yes, Your Honor. Miss Taylor is actually 33 years old. And indeed, she is the victim of identity theft. She has been here in Georgia only for a year, Your Honor. So May 2021, I don't think she was here. And not only that, Your Honor, she was meeting another lady who was trying to help her to get a job here in Georgia. So she remembers clearly to provide all the information to her. And she does not work at Planet Fitness, Your Honor. My client works as a cook at McCormick Warehouse, and she has been working there for a whole year. And she has a high school degree. She also has some college credit, and she has cousins here. Indeed, her mother, who is on the screen right now, Lashana Davis, she's also moving into Georgia because they like their environment here. They have a relationship here, so they are in the middle of the moving here. I have not been able to review the corporate video footage to verify how that person was looking. And even though Mr. Bork, Isaac, and the other person may know this person as a Miss Taylor, however, that is not real Miss Taylor, Your Honor. My client is a victim of the ID theft. We would like to request for a signature on bond for this. Thank you. Oh, by the way, she does not even have a van that she was staying as a homeless person to stay there. It's just not, it's not the fact.
And you said that she's a victim of identity theft. Is that what you stated, Ms. Kim?
Yes, Your Honor. Somebody is portraying that as a Taylor, Miss Taylor, and then doing all these things.
So she was not at the Planet Fitness?
Nope.
If the defense, Your Honor, could provide proof that Ms. Taylor actually was not living or residing in Georgia in May of last year, that would be something we would be very interested in seeing, because if she is a victim of identity theft and this is not her, then naturally we would not have any interest in prosecuting someone and it's the wrong person.
Right. Are you gonna get that to her, Ms. Kim?
Miss Lashana Davis, the mother, maybe, was she living with you at the time in Illinois? May 2021? Oh, you're muted.
You're muted, Ms. Davis.
Mute. Okay, I think I unmuted it.
Yes, we can hear you now.
Okay, I'm not sure of that exact date, but
Hold on 1 second for me,
I don't
Ms.
know if
Davis.
she was.
Ms.
Yes,
Davis,
ma'am.
I
hold
need
on
to
just a
swear
second.
you in if you're going to address the court. I apologize. Raise your right hand for me real quick. Do you
Okay.
affirm Confirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury.
Yes,
Okay, and so you are the mother to the defendant, Ms. Taylor?
yes, ma'am.
Okay, all right, go ahead.
I'm not sure of the exact date that she moved here because it's been a while ago, so I can't say for sure. But I do know that her identification has been stolen on multiple occasions.
Mm-hmm.
So I can't really say the exact date. I'm sorry.
Okay. All right, well, if there's any additional information that you can provide Ms. Kim to give to the prosecutors, then you are free to do that, and Ms. Kim, Kim will forward that to them to make a determination if we have, some act of identity theft that will put your daughter in a different location last year.
Okay. I think that she filed a report for identity theft.
That would be
I
very,
advised her to do so.
yeah, most people do, and hopefully she did, and then we can see what those dates look like, but we're talking about May of last year.
I'll be happy to call
Okay.
my client over the phone, the jail, and then maybe I can get some more additional information about that.
Okay.
So
Yes.
I'll do that. Thank you, Your Honor.
Copies of those police reports would be quite helpful.
Right. And so at this time, your daughter is still living in Georgia, is that correct?
Yes. She lives and works here.
Okay. And do you, or are you somewhere else?
I'm here in Georgia.
Oh, okay. Okay.
Yes.
All right. Well, I'm going to, on this case, I'm going to grant a $3,500 signature bond, and I'm going to grant that through the jail. And of that 3,500, again, the breakdown, what is that math for me?
We have two charges, Your Honor.
Okay,
I asked for 25 on the
first charge.
well, the first charge is a criminal trespass, so 1,000 on that one, and then on the battery, 2,500.
2,500, right. I set them backwards, right?
Yes.
Let's do that, 1,000 on the trespass first charge and 2,500 on the second. That'll be 3,500 signature bond through the jail. No drugs, alcohol, or weapons while on bond. Ms. Taylor, you are to stay away from the Planet Fitness. I do not have the address in front of me, but I'm sure that Ms. Bridget.
854 Oak Street.
Gotcha. And also a stay away from the residence of the victim, Ms. Harwell. Do we have her address?
I'm sorry, Ms. Bridgewater, go ahead.
No, we do not have it. I just put stay away from the home address.
Okay, of Ms. Harwell. If you can get that to her, Ms. Giddings, that'll be fine.
Yeah.
Also, I'm going to order no further contact with the victim, Nosha Harwell. No drugs, alcohol, or weapons while on bond, and that should do it for now. And we'll see where it goes with this identity theft claim.
If I may ask just one quick question, Ms. Kim, your client, I believe, was holding up 3 fingers. Does that mean that this has happened 3 times and she has 3 separate police reports?
I'm actually calling her.
Okay.
I'm on hold from the jail. I'll verify with her.
Okay, well, if you just put that in the chat to me so I can keep a note of that, please, ma'am. Thank you.
Yes, ma'am.
Great. All right, thank you. All right, that will conclude this matter.
Thank you, Your Honor.
Thank you, Your Honor.
Position 2, Graham.
Okay. This is 22 CR 008067C. Cedric Graham, you're charged with 1 count of simple battery family violence. The offense date is February the 17th, 2022. Pretrial.
56 cycles, last arrest December of 2021 for driving while license suspended or revoked in Tifton, Georgia. No disposition listed on that arrest. Record indicates a 2017 purchase or use of drug-related objects, 2012 simple battery family violence, 2012 given false name. 3 violations of probation within the past 10 years. Nothing further to add.
All right, Ms. Sorry.
Yes, Your Honor. This incident took place at 2964 2 Lake Circle. CHENINA, last name McClendon. And the victim stated that the defendant came over to her home to pick up tax documents when all of a sudden he grabbed her by the hair and struck her several times in the head. She did state that these actions were not provoked. Your Honor, we do have a jail call between the defendant and the victim. In this conversation, he told the victim—
Objection, Your Honor. Objection, relevance. The defense has not had the opportunity to listen to any evidence that Ms. Sauer is presenting to this court.
And Your Honor, regarding
on hearing, Your Honor, we would require some notice.
Your Honor, regarding the notice claim here, the defense is not entitled to anything at the bond hearing, so we will provide that information when it is proper. This just happened.
And therefore, Your Honor, we ask that Your Honor not consider that information.
Hold on, Ms. Gant. Hold on, Ms. Gant. Okay.
Thank you, Your Honor. So again, as I was stating, this just happened. So when it is the appropriate time to send it over to the defense, of course, we will send that information over. So I would like to be able to finish my presentation, Your Honor.
Let's tread light on the jail call. Just give me the facts that are in the warrant at this point, and then I will make a determination if I need to hear more to allow a synopsis of the jail call between the victim and the defendant.
Yes, Your Honor. We have heard from pretrial regarding the defendant's history. I would like to point out to the court, his history goes back a far ways, but in 2005, he had a simple battery conviction against a different woman. In 2012, he had a simple battery family violence against another woman. And then in 2013, he had a battery family violence arrest. That was null pros, but that was another woman, the same from 2012. And another 2014 simple assault family violence. So, Your Honor, this defendant does present a risk of reoffending. He's a danger to this community. He has multiple victims, multiple convictions. He does present a significant risk of intimidating the victim, as I've stated regarding the jail calls. He's a multi-county offender. The state's recommendation in this case is a $5,000 surety bond, no contact with the victim, a stay away, 1-day anger awareness, and no drugs, alcohol, or weapons.
All right, Ms. Gant.
Thank you, Honor. Mr. Cedric Graham is 47 years old. He has been in the Atlanta, Georgia area for 30 years. He states that he has 5 children, ages 23, well, a set of twins, age 23, 20 years old, 18 and 16. He also has shared stepchildren with the complaining witness, Ms. Janina McClendon. Your Honor, he does have family in the Atlanta Metro Georgia area, including a cousin. He states that he and Ms. McClendon have been together for 4 years, and they are engaged and set to be married on December 5th. Mr. Graham completed high school. He is self-employed with lawn care. However, due to the seasonal nature of that employment, he is not earning any money at this time, Your Honor. He strongly denies the allegations. We are opposed to any no contact and stay away orders, as it is my client's wish to continue having contact with Ms. McClendon. I did have the occasion to speak out to her, to reach out to her, and she informed me of the same. I do acknowledge my client's history. However, Your Honor, I heard about a conviction back in 2005. That is quite remote. The matters regarding battery were dismissed in 2015 and 2013. I would ask that Your Honor not consider any arrests that have not led to convictions. He clearly isn't a danger to the community. We heard about his last contact with law enforcement legal system was in 2021 for a driving offense. And even 2017, that was a nonviolent offense. And in terms of what else did we have here? We just don't believe that there's anything to warrant the state's assertion that he's a danger to the community, Your Honor. Therefore, Your Honor, I'm requesting a signature bond on Mr. Graham's behalf. If Your Honor determines that he is ineligible, then I would ask for a more reasonable bond, no more than $1,000. And again, we are opposed to any no contact and stay away orders. Thank you, Your Honor.
All right, thank you.
Then we would ask for no violent contact.
And Your Honor, if I may respond regarding the defendant's history, that 2021 arrest, it does include the use of a firearm during the commission or attempted commission of a felony. So that is a violent offense. And to clarify, the simple battery family violence guilty conviction, that was in 2012. Also, Your Honor, I would, due to the fact that the defense is stating that the victim the victim wants contact, I would like to present to the court the jail call that we were able to hear as an officer of this court. Your Honor, I am able to give that information as hearsay is admissible.
And Your Honor, again, we would object. Ms. Chanina McClendon is on the line. She is fully prepared to address the court regarding her desires for contact. And we ask that her testimony be limited to just that, as this again is a bond hearing.
And Your Honor, I'm sorry, one more thing. It's regarding the Ayala factor, that he is a risk of intimidating her. And that's where we believe the phone call comes into play.
All right, I'm going to hold for a second on ruling on that, and I'm going to allow Ms. McClendon to give me some brief testimony, and then I'll see about the call. Ms. McClendon, would you wish to address the court?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, what would you like to tell me?
I do not wish to have a no contact. Me and Cedric is due to get married on December the 5th, and he do not intimidate me at all. And I don't fear for my life, and I'm not scared of him. We got into an altercation, and there was some pushing and shoving. He didn't strike me.
Okay, and are you in fear of Mr. Graham?
No, ma'am.
Okay, how long have you all been dating?
We've been dating for 4 years in a relationship, but we've been on and off in a relationship for over 23 years.
Okay. And you all have been residing together, is that correct?
Yes, ma'am, on and off, because he have a sick mom, so he goes from here to her home.
And then when he's here, sometimes he stays with you, is that correct?
When he's here, he's at my house. Yes, ma'am.
Once you all are married, do you intend to live here in your home, in Atlanta area?
Yes, we'll be here between here and his mom home.
Okay. And where does his mom live again?
And Thompson County.
Thompson County, okay. All right, I think I have enough, Ms. Sorry, from the testimony of the victim, and I have heard what you have stated regarding the witness intimidation, and I've taken that under consideration as well. And so I'm going to not allow the information or your summation of the call at this point. That will be saved later for further hearings in the case.
Your Honor, if I might just briefly interject, this is Anna Allen in the SG's
yes, how are
office.
you?
I'm supervising this afternoon.
Mhm.
Jail calls are specifically relevant, especially at
Objection,
this
Your Honor.
stage in
Your
a
Honor
domestic
has
violence
ruled.
case.
Ms.
I'd
Gant.
actually like to continue and not be
I'm sorry, Ms.
interrupted, Ms.
Gant, right.
Gant.
Please don't interrupt her, Ms. Gant.
There is no obligation for notice and there is no obligation for review by the defense at this point. The Ayala factors are specifically about the risk to intimidate. And if a defendant coming into the Fulton County Jail and getting money put on his books or making free calls after hearing a recording that says this may be recorded and while being under arrest and incarcerated for a violent offense, chooses to have a conversation with someone that they know is not private, that includes a continuation of their crime or an attempt to subjugate perjury or intimidate a witness into changing their testimony or testifying in a court case. All of those things are not only a continued violation of the law, continued evidence in this case, part of an investigation of this case, but it's relevant in a hearing like this, specifically because Your Honor is in charge of deciding whether or not a victim of domestic violence, granted this case is from February, so we don't know when this young lady reported this incident, she reported she'd been assaulted and that the defendant had already fled when police got there. So there are warrants for this defendant since February of 2022 when this happened. So we don't know the status of their relationship today, but what we do know is that the cycle of violence and domestic violence, it would make perfect sense to us that these people are back together and that they share children and that her position today might be different than it was in February when she was in crisis and was asking for help. And ultimately, all the police could do was issue an arrest warrant. That is specifically why the conversations between these two people from the jail after this gentleman has been arrested are relevant, because Your Honor and the community needs to judge whether this person is safe moving forward. And with all due respect, a victim of domestic violence in the cycle of violence is not always in the best position to determine whether or not they are safe. That is why we are here as officers of the court. So I respect your ruling, Your Honor, but I did just want to make sure you understand that our position is jail calls are relevant and they are appropriate and they are actions being taken by incarcerated individuals to try to attempt to change the outcome of their case. And if that is the evidence the state has to present to Your Honor at a hearing like this after someone's been arrested when there's already contact, that is absolutely relevant. It's supported by the law. It's not fun. We don't always like the evidence that's there, but that doesn't mean the evidence isn't proper. Thank you.
And Your Honor, if I may, I would just add that, again, my client is presumed innocent at this point. He enjoys that presumption. These are allegations. And to the state's point, this happened back in February, which, as Your Honor has stated many times, has referenced the cooling off period. Ms. McClendon is here. She has addressed this court regarding her wishes. She also, Your Honor, let me just back up and say that regarding cycles of violence, this is the first incident that is alleged between this couple. So we believe that the state's position is unfounded, Your Honor, and we would ask that Your Honor keep her ruling in place, which the defense respects. Thank you, Your Honor, and I do apologize for interrupting.
All right. Hold for 1 second, please. And then I'll come back and give you a ruling. Hold on. All right, I'm going to allow Ms. Sari to give me a brief synopsis of the jail calls. And these are jail calls from yesterday.
I believe it's from early today. It may have led into yesterday and led into today.
Okay. All right, can you summarize them for me?
Sure, Your Honor. The jail calls that we have in the conversation The defendant told the victim to stop calling the police, and the victim responded that she wouldn't have had to call the police if the defendant didn't do what he did. So we do, with those statements, we do believe that he presents a significant risk of intimidating her. To tell her to stop calling the police is in very nature trying to have her recant her testimony.
Okay. Ms. Gant?
Your Honor, I believe that the information that Ms. Sari just presented to the court is again irrelevant and out of scope and improper. Again, my client is presumed innocent. This is alleged to have occurred back in February. We do not have any repeat incidences. After this point, I would ask that your Honor not consider this inflammatory, prejudicial information, and just, Your Honor, we would ask again for a signature bond or a bond of no more than $1,000, no stay away, and no and that Your Honor not put in place a stay away nor a no contact order. Thank you, Your Honor.
All right.
I'm sorry, one thing, Your Honor, just due to the fact that we're presenting regarding the risk of intimidating, and the defense stated that the calls are prejudicial. As we know, with the rules of evidence, prejudicial is not the proper standard. It's whether it's unfairly prejudicial. And in this case, being that intimidating the victim is a relevant Ayala factor, there's no unfair prejudice in this case.
Yeah,
And Your Honor, we would disagree, and we would disagree because again, we have no notice whatsoever of this testimony. We have Ms. McClendon here presenting a totally different version. We don't even know if these telephone calls happen. And I am not here before you stating that I disagree with Ms. Sari, but if the defense had notice of this, then we would be in a position to address this, Your Honor. It is unfairly prejudicial, if I may go further to add that adjective.
Yeah, I disagree. I don't believe it's prejudicial. And I disagree to say that the state would bring up some jail calls from last night or this morning, and we're not sure that they even exist or that they happened. As you know, they have access to listen to the jail calls, and they have. And I do agree and understand that process. And I don't believe that it's any more prejudicial. I think it certainly goes toward my Ayala factors that I'm weighing in determining bond and conditions regarding the bond for the defendant in this case. Ms. McClendon, we're arguing a legal matter at this point. I have heard from you. I'm not sure that there's much more that I need to hear. I'm going to give you about 2 seconds to say one last thing and not speak about the law. But is there anything else that you're raising your hand that you want to tell me about this matter?
Yes, I was trying to let you all know that basically y'all don't have a case because I'm not going to pursue anything.
That's
I'm not going to
again,
do anything against it.
at this point, the police were called. We have a warrant. We've passed probable cause, so the case will go forward. And so I thought you were going to give me some other factors. And as I stated, that's a legal issue or a legal matter that will be handled as we go forward. We're here right now to determine bond.
Okay.
All right. And whether this defendant will be a good candidate for which type of bond, whether he's going to reappear, whether he's not going to intimidate you as the process goes on. So we are here to protect you as well as making sure that you will be safe from any future harm that might come to you on behalf of the defendant, okay? All right, so I'm going to rule on this case. I'm going to enter a $5,000 surety bond. I'm going to, with that surety bond, and based on the evidence and the testimony that I've heard, I'm going to order that there be no further contact with the victim, Shanina McClendon. I'm going to order that Mr. Graham stay away at this point from 2964 Two Lake Circle, which is the incident location. I'm going to order that he have no drugs, alcohol, or weapons while on bond. And I think that's all that I need to take up. Is that correct, counsel? Anything else?
Nothing
Your
further
Honor,
from the state, Your Honor.
All right,
may Your
thank you.
Honor, add a one-time law enforcement escort and third-party transfer.
Okay, I did not understand. Are there children involved? How many?
He has 5 children, but he states that he is involved in the care of Ms. McClendon's children, and I do not know the ages, Your Honor.
I want to only know about children that they have together. Ms. McClendon, do you have any children together that Mr. Graham is the father of, the legal father? I'm sorry, go ahead, Ms. McClendon.
Can you repeat the question?
I said, is Mr. Graham the father, legal father of any of your children?
No.
Or biological father? He is not?
No, but
Okay. Okay.
He's the only father that my son has in his life.
Okay, I understand. Since he's not the biological father, the legal father, or anything of the children, I'm not going to order, or that'll be up to you, but you also understand that there is a no contact provision to this bond between you and Mr. Graham. So I assume that visitation will not be had between the two of you. I don't know how old this child is. So you need to govern yourself real careful if there's going to be any visitation that is facilitated by you, because it could cause Mr. Graham to be in violation of his bond by having the contact with you regarding that. But I will order a one-time police escort for Mr. Graham to come back to the property to retrieve any of his personal items.
So how would, if you saying no contact, how would he be inactive with my son? Because I'm not requesting that. And I'm going to go against it because I'm going to have me and him getting married on December the 5th.
Okay, well, he'll be in violation of the order and the state can revoke his bond and he would be rearrested. So you need to be very.
But how would you place that order if I'm telling you that I don't need that?
Well, we understand the cycles of violence and we understand what's going on. And
I don't need you to protect me.
Okay.
I don't need you for protection.
That's fine, but govern yourself accordingly. He's under a bond.
Okay.
All right. Thank you.
Mm-hmm.
Next case.
Thank you, Your Honor.
Ramos?
What number again, Deputy?
Position 7, Ramos.
All right, thank you. This is 22 CR 008071A. Ricardo Ramos, you charged with 1 count of battery family violence. The offense date is October the 9th, 2022. Pre-trial?
No prior history.
Okay. All right. And this is Ms. Todd's case, ASG Todd.
Yes, it is, Your Honor.
All right, go ahead.
What started as a verbal altercation between the defendant and his boyfriend, Levi King, both common spelling, escalated when the defendant began striking Mr. King, leaving multiple scratches across his face. As pretrial stated, this is his first arrest. However, our office was able to speak with the victim, and he indicated that he wants no further contact with the defendant, and he would like for him to stay away from his home location, which is 214 Old Bladesville, that's BLAIDSVILLE Highway. Additionally, we are asking for a $3,000 surety bond for this case. Nothing further.
All right, PD Kim.
Yes, Your Honor. Mr. Ramos is 22 years old, Your Honor. He is qualified for unsecured judicial relief. This is his first arrest ever, Your Honor. And he has been here in Georgia for 22 years. All his life, his parents, his brother, sister, everybody is here. And he is also gainfully employed as a full-time house security guard. He's been working there for about 8 months, and he graduated from high school and he has some college education. We would like to request for a signature on bond. He's totally okay with stay away, no further contact. So, and they broke up. So there is no reason for any kind of intimidation to the witness. And he has a strong ties to the community, and he's not a flight risk, Your Honor. Thank you.
All right.
And I apologize, Your Honor, if I may.
Uh-huh.
I did forget to mention a no drugs, alcohol, or weapons while on bond for this matter. It is alleged that he was drinking when the fight started.
Okay.
No objection.
All right. All right, I'm going to order the $3,000 signature bond through pretrial. I'm going to order that there be a stay away from 214 Old Bladeville Highway. And did I hear a no further contact or not from the state?
Yes, Your Honor, the victim has requested no further contact.
Okay, no further contact with the victim in this case. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to, well, I think that's it, counsel. Anything else? Any other recommendations by the state?
No, Your Honor.
All right, thank you.
Judge, what's the dollar amount?
$3,000 signature bond through
Thank you.
pretrial.
Thank you.
Uh-huh.
Next, we have position 1, Barry.
Okay. This is 22 CR 008076D, David Berry, charge of 1 count of willful obstruction of a law enforcement officer. The offense date is November the 30th, 2022. Pretrial.
Cycles with history out of Georgia and Texas.
How many? I didn't hear you.
6.
Okay.
Total of 6. Multi-state offender in Georgia and Texas. Last arrest, May of this year, theft by shoplifting in Fulton County. That was a conviction under case 22 CR 003236. Sentenced May of this year, 6 months probation. Record also indicates a 2013 assault causing bodily injury, family violence in Texas. Nothing further to add.
Okay. State.
Your Honor, this incident took place at 2261 Cascade Road in Atlanta. While officers were in the process of arresting an individual for drug-related offenses, the defendant was standing close to the officer. That individual that was being arrested was resisting, and he eventually removed the bag from his person. The defendant then picked up the bag in an effort to remove the evidence from the scene. The officer ordered the defendant to put the bag down and arrested him. And a search incident to arrest revealed the bag, in the bag revealed that there was crack cocaine, oxycodone pills, wax, and a scale. As we've heard, the defendant does have a criminal history, which the state is concerned that he is a risk of reoffending, as well as the history out of Texas. So he is a multi-state offender. The recommendation is a $2,000 surety bond, no contact with Jamal Hartsfield, that would be the co-defendant, and no drugs, alcohol, or weapons.
All right.
Your Honor, my client is 37 years old. He has a bachelor's degree. He is the father of two young children, two young boys, which he's raising by himself, 13 and 14 years old. He's been raising them by himself for the past 6 years since their mother died. He's a single father. In fact, those two boys were at home yesterday when my client was arrested. This is a case, Your Honor, of extreme police overreach. My client simply went to the convenience store to buy a bear. He just got home from work. He wanted to relax, have a bear. He went to the convenience store. I have read the warrant several times over. They said that my client picked up this bag. The police officer instructed him to put the bag down, and he did. Nevertheless, they arrested him. I do not see the elements or obstruction in this, Your Honor. The police officer said he asked my client to give him his name, and he did. Said he asked my client for his date of birth. My client said he wasn't going to tell him, and then he told him. I do not see the basis for this arrest. I think it's a case of police overreach, Your Honor. And as to the issue of my client's record, he only has 2 convictions based on what I heard the trial say. One was 2013 and a nonviolent offense, shoplifting. I understand the trial said that this happened sometime earlier this year. I maintain that my client did nothing wrong to have caused him to be arrested, just obstruction, standing on his head. What did he do? He was an innocent bystander. He was not involved in the drug transaction that was described in that warrant. He just happened to be there, and then he ends up being arrested. Your Honor, I would ask the court to give my client a signature bond so he can get out of jail and take care of his 2 boys who are alone at home now. Fortunately, the older one is 14, but this is just not something good. He didn't expect any of this, doesn't have anybody to help him with the kids, and this is definitely overreach, Your Honor. Thank you.
And Your Honor, briefly regarding the history, as pretrial has stated, there's a 2013 guilty conviction for that was a violent offense. 2011, a DUI, that was a NOLO. In Georgia, he has a 2022 theft by shoplifting guilty conviction and a 2021 criminal damage to property in the 1st degree. So his history is not as remote, and he does have guilty convictions, as well as, Your Honor, interfering with the police investigation and arrest is not something that should be taken lightly. So again, the state's recommendation in this case is a $2,000 surety bond with the conditions previously stated. Nothing further.
Your Honor, I still maintain that his criminal history, which is not significant, does not justify what happened here. This, I maintain, is a case of extreme police overreach. This man did not do anything. He picked up the bag. When the police officer said, put it back down, he did that. I cannot imagine that a police officer would think that that was sufficient to justify an arrest here, Your Honor. And I maintain that in the eyes of the public or a court of law, people would see it that way. That was an improper arrest. And I believe that justifies my client getting a signature bond so he can go home and take care of his 2 kids.
I'm not sure that, I'm sorry?
Nothing further, Your Honor.
All right, thank you. I'm not sure actually that the fact of arguing that is not a proper arrest would allow me to just give the signature bond. There's some other factors obviously that weigh a lot heavier into a signature bond versus a surety bond. And I have heard the criminal history, and I have to weigh that with other factors. He obviously has the contacts, he has the children that he needs to take care of. So I do understand that. And you said that he was working, correct?
Yes, he is employed, Your Honor. He was coming from work when all of this happened. He tells me he doesn't even believe his children were able to go to school today because he doesn't have anyone else to take care of them.
Okay. And what was your recommendation again, Ms. Sorry?
Sorry, it was a $2,000 surety bond. The bond currently set is $2,500. So these facts were reviewed by a judge previously. So we are willing to go down on the bond to 2,000 surety.
Your Honor, I still believe that my client's criminal history is not such that he is not able to get a signature bond. We have to take into consideration all the facts and circumstances, the allegations and the warrant, all of that. He was simply standing by. To trump up a charge of obstruction under these circumstances is absolutely unconscionable and unacceptable.
And Your Honor, I do hear the defense's argument. However, I gave the facts based off the warrant relating to the defendant, but relating to the person that was being arrested, he was actively resisting. He was attempting to flee. He's trying to get away while he has drugs on his person. So for this defendant to get involved in this situation, it is obstruction, and that's why we are charging it as such.
I disagree that it is an obstruction. In this day and age, sometimes citizens have to stand up to see what the police are doing. The police also need oversight. They are not free agents to do whatever they like out in public. And we've seen many instances of police officer overreach, and I think this is a classic example of it.
All right, argument is heard on both sides. I did hear Ms. Sorry state that, and I think you confirmed a little bit of it, PD McLeod, and that is our conflict defender McLeod, is when he was asked, he didn't do it, he did, then he did give it and he didn't. And those things are considered problematic, as you know, for officers when they do ask for ID, ask for names, ask for cooperation, and persons resist or do not want to cooperate, and then they do after they think about it. Then it may or may not be too late to kind of turn it around or change the situation, at that time. So what I'm going to do on this case is I am going to give a 3,500 signature bond through pretrial. I am going to order a stay away from the incident location. I'm going to order no drugs, alcohol, or weapons while on bond. And I don't think there was no further contact request, was there?
No, Your Honor, because there's no indication that he even knows any of these other people.
Your Honor, the state did request a no contact order, just for the record.
All right, and who's that? No further contact with whom?
His name is Jamal. Last name is Hartsfield. That's HARTSFIELD.
Okay.
My client doesn't know this person, Your Honor.
All right, then he shouldn't have a problem having no further contact with him. So we'll say no further contact with Jamal Hartsfield and a stay away from the incident location. And that's
Your Honor, the incident location was his neighborhood corner store that he normally goes to buy things. To say that he should stay away from there under these circumstances, Your Honor, I don't think that is proper. I think this is punishing him when really and truly just went to buy a beer. A citizen has that right.
I understand, and I'm sure there's another corner store that he can go buy his beer at on his way home until we can sort things out and have the full evidentiary hearing. I'm going to order him to stay away from that corner store, to have no further contact with this person, Jamal, to make sure that it certainly will not lead to anything further. Probably, also for his protection as well, go to a different store, don't even frequent there, and stay away from this person. And hopefully it will be sorted out by the time he has his hearing. And you can put up further evidence at that time. But that is the ruling of the court.
Thank you, Your Honor.
All right, you're welcome.
And I'm sorry, Your Honor, was just reviewing the pretrial report. He wasn't recommended. Is that per judge?
It is per judge, yes.
Thank you.
And also, I do have that plea paperwork.
All right.
Your Honor, my business today is concluded before the court. May I be excused?
Yes, you may. Thank you.
Thank you. You're welcome, Your Honor.
Mhm. So I have pleas on positions 5 and 9. Are we done with all other cases?
Yes, ma'am.
Okay.
Judge, what was the bond amount, please?
$3,500, I'm sorry, Judge.
No, go ahead.
$3,500 SOB through pretrial per judge.
Thank you. Position 9, Stephens. Stevens, he's taking a plea. Come on, Mr. Stevens.
All right, we can hear you. Hey, you're Mr. We can, the background noise is. All right, this is Mr. Richard Stevens, is that correct? Is it Stevens or Stephens?
Yes, Your Honor.
I'm sorry?
Yes, Your Honor.
Okay, this is case number 22 CR 008073H. And I understand that you wish to plead guilty to 1 count of criminal trespass with the offense date of November 30, 2022. Is that correct?
Yes, ma'am.
Okay, and you're wishing to go forward without representation?
Yes, ma'am.
And you understand the consequences of going forward representing yourself, right?
Yes, ma'am.
You are to know the laws and no one can advise you, and you're to follow the rules of evidence. Are you clear on that?
Yes, ma'am.
Okay. And so let me hear from the state first to get the factual basis and understand what the plea is, and then I'll come back to you. Okay? All right. And Ms. Todd, ASG Todd, you're going to take the plea?
Yes, I am, Your Honor.
All right, go ahead and give me the factual basis.
Okay, the factual basis is, as of yesterday, the defendant walked into the Publix located at 950 West Peachtree Street Northwest. He was recognized by the on-duty manager at the time, who as a person who has been criminally trespassed from this Publix in the past. The state is asking for 12 months to serve, 1 day with credit for time served, a balance suspended, a stay away from the Publix at 950 West Peachtree Street.
Okay. 950 West Peachtree. And give me that again, 12 months. Balance suspended.
Yes, ma'am. It is 12 months to serve, 1 day, credit for time served, balance suspended.
And you will just be on probation for 12 months. All right. And so, Mr. Stevens, did you hear the plea offer by the state?
Yes, Your Honor, but to my understanding that if it was time served, I don't have any probation at all. But I mean, because it's 12 months time served, but you still have probation.
It's suspended. You don't have to report or pay anything, but you will be on 12 months probation to make sure you don't commit any other offenses in the 12-month period. And then after that, you will be totally free.
Yes, ma'am.
Judge, I'm sorry to interrupt your ruling. We do not have probation on the line at this time to inquire of contacting information. If you're
Okay,
going to, because I thought it was a 12 month suspended.
Yeah.
Oh, is it suspended or probated? I'm sorry.
No, it's suspended.
Oh,
and what
I'm
he was
sorry.
saying was correct.
Yes, I'm sorry. I stand corrected. I will definitely not be too shy about saying I was incorrect. I am sorry, Mr. Stevens, you are correct. It
No
is
problem,
suspended.
Your Honor.
I said one thing and had another thought in my brain, so please pardon me, okay?
Yes, ma'am.
It is suspended and you will not be on probation. I'm so sorry.
Yes, ma'am.
All right. And so is there anything else we need to take up first before I,
Your Honor, I have a question though.
yes.
By him having a special condition of not going back to Publix, that draws a red.
It's only for a year.
It's only a year.
It's
Ms.
non-reporting
Collins.
probation. So he can't go back to that Publix for a whole year.
For a whole year. It's almost suspended, Ms. Holly. It's fine.
Okay.
He can have suspended with conditions, correct?
Okay.
That's correct, Judge. He can. That's
Yes.
correct.
Right. He can have
I
suspended.
don't worry about me going back there.
I'm sorry, Mr. Stevens?
Them people chain me to, excuse me, off the court record, them people chain me to it. Table.
Can't hear you, it's a little fuzzy. Tell me
It's,
again.
They chained me to a table from 11:30 yesterday morning to 5 o'clock yesterday evening about a soda. I promise I ain't going back there anymore.
Okay, that's all I want to hear. You're not gonna go back. Even though you're not reporting as suspended, you do have that condition. And so as long as you're gonna do that, I will not see you again. That is correct?
Yes, ma'am.
Okay, well, do this for me. Can you raise your right hand? Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am. I'm not swearing, I'm just raising my right hand, right?
Okay, that's good enough. I can see it. All right, you can put it down. And I'm gonna ask you a series of questions in order to take your plea. And that is the first one being, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Okay, and are you satisfied, well, you're representing yourself, but do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're giving up or waiving the right to trial by judge or jury, whichever you would prefer?
Yes, ma'am.
And do you understand, again, the rights that you're waiving and you're prepared and agree to waive those rights today?
Yes, ma'am.
And do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you are currently on probation, your probation could be revoked because of your guilty plea here today?
Yes, ma'am.
And do you understand, again, and offer this guilty plea freely and voluntarily with the full understanding of the charge against you,
Yes, ma'am.
which is the criminal trespass, correct?
Yes, ma'am.
And how do you plead to that charge?
Guilty, ma'am.
All right, so I will accept your plea, and that is 12 months probation to serve 1 day. 1 day has been served, credit for time served, balance is suspended, and the condition is to stay away from the Publix supermarket or grocery store at 950 West Peachtree Street for the 12 months that you're on the suspended probation, okay?
Yes, ma'am.
All right, so you will be released within the 24-hour period or when the jail finishes processing you, okay?
Yes, ma'am.
All right, good luck to you.
Thank you, Ms. Mitchell.
Position 5, Johnson.
All right.
Good afternoon, Judge.
Good afternoon. All right, this is 22 CR 008066E, Christian Bradley Johnson. You're charged with 1 count of criminal trespass. The offense date is November 30th, 2022. State.
Thank you, Your Honor. Yesterday, while on patrol, Officer William Glover and his partner, Officer Smith, were on patrol near the Family Food Mart located at 12 Atlanta Avenue. When they noticed the defendant walk out of the store, they recognized him as an individual who had been criminally trespassed from that store on multiple occasions at prior times. The state is offering 12 months to serve 1 day, credit for time served, a balance suspended, and a stay away from the food mart at 12 Atlanta Avenue. Nothing further.
All right, that's the food mart, 12 Atlanta Avenue.
Yes, Your Honor.
Okay. All right, Mr. Johnson.
Yes, ma'am.
All right, is my understanding that you wish to take a plea today
Yes,
and you wish to represent yourself, is that correct?
yes, ma'am.
You understand the consequences of representing yourself?
Yes, ma'am.
And you're to know the laws and the rules of evidence for Georgia, correct?
Correct, Your Honor.
All right, and so you wish to proceed without counsel, correct?
Correct, Your Honor.
All right, raise your right hand for me so I can take your plea. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes,
All right, and again, I'm going to ask you a series of questions to make sure that you understand what you're doing here today. Are you presently under the influence of any medication, drugs, or alcohol at this time?
not at any time, Your Honor.
All right, are you satisfied with the services and representation? I'm sorry, I am getting ahead of myself. You're representing yourself, so I assume you're satisfied. Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
You're absolutely correct, Your Honor.
Okay, do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
I'm gonna remain silent, Your Honor.
All right, do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am, I do, Your Honor.
All right, and are you again prepared and agree to waive these rights today?
Of course, Your Honor.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
Not that I'm sure of, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
All right, do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am, Judge.
Okay, and again, do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you, which is 1 count of criminal trespass?
With all due respect, Your Honor, I do.
All right, and as to that count of criminal trespass, how do you plead?
I plead guilty, Your Honor.
All right, I will accept your guilty plea. And again, you're given a 12 months sentence, which is going to be balance suspended, 12 months to serve 1 day, credit for time served at the 1 day. And again, you will not be reporting, but you will have the probation suspended. And the condition for your probation is that you are agreeing to stay away and not return to that food mart at 12 Atlanta Avenue. Do you understand that?
Come on with it, Your Honor.
And you will not return there, correct?
Correct, Your Honor.
Okay, good. All right, I appreciate it. Good luck to you. I'll accept your plea, okay?
Thank you, Your Honor, and your team.
All right.
Okay, I think that was everything.
Yes, ma'am.
Someone tell me what happened with Robert Brooks?
What
He was
number?
on the poll sheet.
That's NOD.
Correct.
Oh, okay.
Yes, that was an NOD.
We're completed here in courtroom 2, Judge.
Sorry.
We're completed here in courtroom 2, Judge.
All right, have a good afternoon. Take
Thank
care.
you, Judge. I needed that.
All right, thanks.
Okay. Oh, okay. Okay, are we ready?
Yes, please.
Okay, once again, the reset date for the SAP calendar is December the 15th. Position number 1 is reset further notice with a $3,500 SOB through pretrial per judge. Position number 2 is going to the SAP calendar with a $5,000 good bond. Position 3 going to the SAP calendar with a $15,000 total good bond. Position 4 is reset to the SAP calendar with a total $3,000 good bond. Position 5 took a plea. Position 6 is going to the SAP calendar with a $2,500 total good bond. Position 7, SAP calendar. I take that back. SAP, no, well, wait a minute. Number 7, I have a $3,000 SOB through pretrial, which is reset further notice.
Correct.
Position 8, reset further notice with a $2,000 SOB through pretrial. Position 9 took a plea. Position 10, reset further notice with a $3,500 total SOB through the jail. And position 11 is going to the SAP calendar with a $2,000 good bond. Are there any questions, comments, or corrections?
No. None from the state on this side.
Great.
Anybody else? Okay.
We've had a fun time. I've enjoyed it, and I will see you all next time.
Are you with us tomorrow, Your Honor?
I'm sorry?
Are you with us tomorrow?
I have one more day.
Okay, all right.
Yeah, we normally don't do this, but we've got some other things going on. Normally wouldn't see us this many days in a row,
Yeah.
but such is life sometimes.
All
So
right.
we'll come back tomorrow.